Greetings, everyone. Is there anyone out there? If there's anyone out there, please hit a 1 in the chat. Type something in there so I know there's an audience. We're going to be going over a very interesting topic today. Parks, squares, and playgrounds from American Jurisprudence. All right, we got some people here. Excellent. And please hit the like if you are just arriving. Let's get started. Before we do, I just want to say we're going to be using Black's Law Dictionary, 9th edition, for definitions of any words we come across that might be used differently in this context or unfamiliar otherwise. And if there's any questions along the way, please just note it in chat. I'll be monitoring the chat. Also, if the audio, for some reason, if it doesn't sound right, please let me know. And let's get started. So, let's see here. American Jurisprudence, 2nd edition, Parks, Squares, and Playgrounds. Let's look at the summary here. This article discusses the law relating to public parks, squares, and playgrounds, including the establishment, control, and management thereof, proprietary rights in and Title II parklands, permissible uses of parks, abandonment and discontinuance thereof, tort liability for injuries received therein, and incidental remedies and procedural questions relating to parks. This article discusses briefly the establishment and maintenance of the national park system. And treat elsewhere, we'll see the condemnation of parklands through eminent domain, discrimination in usage of parks, easements, establishment, maintenance, liability, etc., are all covered in other volumes of American jurisprudence or in other sections of this one. Let's proceed. Okay. Right to hunt and fish in public lands and waters. See the American jurisprudence. Oh, we still got more of these here. Sorry. Okay, let's get right to it. The introduction. Definitions. Historically, a park was understood to be an open square or plaza, usually containing shade trees and seats. And although the idea of an open air space with land kept in a natural state of grass and trees still inheres in the general understanding of the word park, landscaping has modified the concept in the trimming away of thickets and underbrush and the inclusion of paved and artificially lighted pathways now also enter into the accepted idea of a park. Thus, the term park means a piece of ground acquired by a city, town, or other public authority for ornament and as a place for the resort of the public, for recreation and amusement, as well as grounds set apart for the public health and welfare. A park is a pleasure ground set apart for recreation of the public to promote its health and enjoyment. In modern times, the principal purpose of a park, namely public recreation, is not limited to physical recreation, but includes aesthetic recreation and mental and cultural entertainment as well. A park is laid out in walks, drives, and recreation grounds, so as to afford pleasure to the eye, as well as opportunity for open air recreation. Parks are set apart and maintained by cities as places conducive to the health, pleasure, comfort, and amusement of the public, and the enjoyment of fresh air and sunshine, and also of the grass, flowers, and trees, is the most important in securing the social, physical, and moral well being of the people. And parks, as a means of providing these bounties of nature for all people, have come to be considered as essentially necessary. A park may be located without as well as within municipal limits. A person may enclose his or her own land and style it a park, or give that name to his or her place, without giving it to the public any right to its use. For in such a case, there would be no semblance of dedication, but the meaning of a word is to be determined by the circumstances connected with its use. Thus, an area around a town's reservoir or pool, which was owned and operated as part of the town's waterworks system, is not a public park, even though such an area had been used as a picnic ground for many years with the knowledge of the town authorities. The term park also includes amenities within the park that allows the user to continue to use the park without leaving to use certain facilities, such as a restroom. Similarly, the word square indicates a public use either for purposes of a free passage or to be ornamented and improved for grounds of pleasure, amusement, recreation, or health. An observation here is the definition of a park may, in some jurisdictions, be provided by statute or other legislative act. A wildlife refuge, while not within the conventional definition of a park, may be within the meaning of that term as intended by its use in a constitutional provision. And that's footnote 16. So as we see here, some of these things we just read here are actually from Ocean Beach Realty versus City of Miami Beach in 1908. 1932, I'm sorry, and that's Morrow versus Highland Grove, and that's in Pennsylvania in 1908. And again, we'll see this City of Miami Beach and Ocean Beach Realty, 1932. And again, Morrow versus Highland Grove Traction Company, and that's Pennsylvania, 1908. So we got some pretty old stuff here. Montgomery Ward, South Park Commissioners versus Montgomery Ward, and that's Massachusetts. So we got some pretty well-established case law in 1910. Here's one from 1991 in Nebraska, and 1949, and there's another one 1986 in Wisconsin. So let's continue here. There was 16 was another footnote. We're looking at State versus Leviton, Wisconsin, 1929. So that's a well-established case as well. And that means the definition of park, that was 15, but 16 is a wildlife refuge. While not within the conventional definition of park, may be within the meaning of that term as intended by its use in a constitutional provision. So that's something to be aware of, and that's 16. That where was that again? Wisconsin. So let's continue here. 1929. Hartman versus Haggerty Farms. I didn't see that one here. Don't see it. Did I pass it? I didn't see it here. All right. Well, if you see it, let me know. Oh, sorry, man. I'm not up with the pop culture, even the old stuff. All right, here we go. The organization or establishment of park districts is sometimes provided by statute, as well as by way of local regulation, such as an ordinance. So we can organize or establish park districts through ordinance or statute. Such enactments have been upheld against various objections on constitutional grounds. Once established in pursuance of the act creating it, a park district becomes a municipality for certain purposes, and its powers, as such, are subservient to the legislative power, precisely as in the case of other municipalities. The taxpayer of an incorporated park district does not have any vested right in the property of the district or to have the corporation continue in existence. Interesting here. A taxpayer of an incorporated park district does not have a vested right in the property of the district or to have corporation continue in existence. That's footnote 5, 1935. Chicago Park District. Interesting there. So we have a few case laws here. Akron, Ohio, in 1994 here. Interesting there, but the rest is 1999. In Ohio also. So there's some pretty recent rulings here. 1930, 1935, of course, what we just looked at. Let's continue. National Park System. Congress has provided for the creation and administration of a National Park Service, that is the Department of the Interior, in order to fulfill Congress's specific goals and purposes. Now we're getting into the the meat of this here, because the purpose of the National Park Service is to promote and regulate the use of federal areas known as national parks, monuments, and reservations, except such as are under the jurisdiction of the Secretary of the Army, by such means and measures as conform to the fundamental purpose of said parks, monuments, and reservations, which purpose is to conserve the scenery and the natural and historic objects and the wildlife therein, and to provide for the enjoyment of the same in such manner and by such means as will leave them unimpaired for the enjoyment of future generations. I want to pause on this for a moment here, and that's footnote 3, and that's under U.S. Code, section 1. Okay, 16 U.S.C. So what I want to say here is that there are some recent laws that were passed involving photography in national parks. They lost on some cases, the National Park Service did, to try to prevent people doing YouTube and TikTok videos in parks. And apparently, because the courts threw out that provision they were trying to impose, the national park has doubled down on their somewhat archaic rule of requiring permit for any kind of photography, which harkens back to the days of, before cell phone photography and such, where commercial photography actually required a film crew, whereas now it doesn't. So if you are doing any kind of YouTube videos or anything like that that might be considered commercial, then they're trying to impose this permitting process, which means you file a permitting fee whether or not it gets accepted. They collect it. So these laws, I'm bringing this up right now because we want to be very sure that what they're claiming is lawful in this day and age, because remember, we got to get back to constitutional provisions here, which purpose is to conserve the scenery. Okay, so by taking photography for your YouTube channel, making money off it, let's just take it all the way, purely for profit. Okay, so again, such means meant to conform to the fundamental purpose. So let's see the fundamental purpose, which purpose is to conserve the scenery and the natural and historic objects and the wildlife therein. So we're conserving that. We're conserving this in many ways, both by not disturbing it with film or video, but by capturing it for posterity in that manner and not disturbing it. And to provide for the enjoyment of the same in such manner, which by doing photography you are, and by such means as will leave them unimpaired for the enjoyment of future generations. And I believe that would fit the bill too. And that's, again, U.S. Code. Again, this is not to be construed as any kind of legal or lawful advice in any way, shape, or form. I have no knowledge or expertise in that field, and this is purely for entertainment purposes. Do not try this at home. National Park Service can act only within its statutory authority. The Department of the Interior's plenary authority over the administration of public lands includes minerals on those lands. Additionally, the Department of Interior has broad discretion in determining what actions are best calculated to protect park or public land resources, including but not limited to asserting reserved water rights, acquiring water rights and rights of way, denying land exchanges and rights of way that may constitute or aid a threat to resources, and bringing trespass or nuisance actions if appropriate. So that's where the National Park Service comes in. Well, that's what I believe. I mean, it seems that's the way it should be construed. However, we're finding that it's not being interpreted that way all the time through the courts. So the more people that are aware of these fundamental rights and the purposes to them, then I believe it'll be easier to construct cases that will win and not end up losing or creating more unnecessary regulations and unnecessary complexity, which goes against the spirit of these laws. Okay. Additionally, the Department of the Interior has broad discretion in determining what actions are best calculated to protect park or public land resources, including but not limited to asserting reserved water rights, acquiring water rights and rights of way, denying land exchanges and rights of way that may constitute or aid a threat to resources, and bringing trespass or nuisance actions if appropriate. Now that's where I get at. Is what's appropriate for a nuisance action? Under footnote 6 is Sierra Club versus Andrus. This is 1981 in the DC Circuit. Okay, so that's something to look into. The Secretary of the Interior is also responsible for maintaining national parks and for providing facilities and services for their public enjoyment through concessionaires or otherwise. So it's Secretary of Interior is responsible for providing facilities and services through concessionaires or otherwise. In order to facilitate the administration of the national park system, the Secretary of the Interior is authorized to regulate and implement rules regarding transportation, recreation, park equipment, purchases, services, resources, or water contracts, advisory committees, and exhibits and demonstrations. The Secretary is also authorized to promulgate policy and regulations regarding law enforcement activities within the national park system. So that's your, what do you call it, the forest rangers, right? The grant of authority to the Secretary of the Interior to make rules for the use and management of national parks and monuments as he or she may deem necessary or proper is very broad. Footnote 10. How do we make this very broad? That's Wilkinson versus Department of Interior, 1986, Colorado, as the regulation of highways pass through national parks. Ooh. Highways. Under the United States Park Service, like any other government agency, must conform to the Administrative Procedure Act's notice and comment requirements when engaging in any informal agency rulemaking procedures unless properly relying on an exception thereunder. So if there's an exception to the Administrative Procedure Act, in order to facilitate the administration of the national park system. All right, so briefly, the Administrative Procedure Act's notice and comment requirements means that before they can implement or engage in any kind of agency rulemaking, that they have to have a period of public commentary and feedback before they can go through that process and have it finalized. In order to facilitate the administration of the national park system, the exception, no, the exception is not the Constitution for them. That we're talking about when any other government agency, just like any other government agency, they must conform to the Administrative Procedures Act's notice and comment requirements unless properly relying on an exception to it. So that'd be an exception to the public comment process, or any other part of that process of the rulemaking procedures, is what they're referring to the exception of. So they're talking about a way for them to get around these procedures, which would involve public comment requirements. All right, but thanks for that highlight there. It's important for us to be very aware of this because every word counts and these sentences are well structured to hopefully communicate it clearly, but it does frequently take more than one reading of the sentence to get it right. And you'll catch me doing it a few times where I have to reread a sentence because you can tell it's something more in there than you get on first reading, and it's worth taking the time to read it again and make sure you leave no word behind. All right, let's continue. In order to facilitate the administration of the national park system, the Secretary of the Interior is is authorized to use applicable appropriations for various activities, including emergency rescue services, the erection and maintenance of utility facilities, transportation of park employees, utility services for concessioners, contracts for utility facilities, the acquisition of rights of way, and for the operation and maintenance of motor and other equipment used on federal projects. So that's the Secretary of Interior is authorized to use applicable appropriations. The Secretary of the Interior is authorized to enter into cooperative agreements with state, local, or tribal governments, other federal agencies, other public entities, educational institutions, private nonprofit organizations, or participating private landowners for the purpose of protecting natural resources of units of the national park system through collaborative efforts on land inside and outside of national park system units. The cooperative agreement must provide clear and direct benefits to park natural resources and must contain the terms and conditions specified in the statute. Footnote 13 is a statute, it's USC, section 16. So that's what this is all based on, isn't it? 16 USC, section 1 for national parks. Okay, so here we go. Cumulative supplement cases. So let's look at this one here. A National Trail System Act empowers the Secretary of Interior to establish the location and width of the Appalachian Trail by entering into rights-of-way agreements with other federal agencies, as well as states, local governments, and private landowners. And that's from 2020. United States Forest Service versus the Cowpasture River Preservation Association. Interesting. Here we have Sierra Club, some of these private nonprofit organizations. All right, let's continue here. And we're on to establishment and maintenance. Of course, we get these forms here. Nice thing about American Jurisprudence, we got everything you need for doing your practice within these volumes. Okay, under common law, parks, squares, and the like may be established by a dedication of land for such purpose, and the matter is frequently governed, in many respects, by statutory provision. The validity of the statutes relating to the establishment or maintenance of parks has in several instances been held unaffected by the presence of separable unconstitutional provisions therein. So look at this. The validity of the statutes have in several instances been held unaffected, meaning that their validity is still in effect by the presence of separable unconstitutional provisions. So if you can separate some of the unconstitutional provisions inside of a statute, right, then this is one of those instances where it can be held unaffected, the validity of the statute in general, if it could be a separable unconstitutional provision therein. Such enactments have been sustained against the contention that they constituted local or special legislation, notwithstanding terms limiting their application to cities of a prescribed population. Furthermore, Congress cannot, by a purported perpetual dedication of lands to the United States for a public park, deprive itself of the power to devote such lands to other uses. Woohoo! Interesting. So, such enactments have been sustained against the contention that they constituted local or special legislation, notwithstanding terms limiting their application to cities of a prescribed population. So, yeah, this is special legislation notwithstanding terms limiting their application. I get it. So you can't have a prescribed population having limited application of the terms. I like this one here, though. Furthermore, Congress cannot, by a purported perpetual dedication of lands of the United States for a public park, a purported perpetual dedication of lands, cannot deprive itself of the power to devote such lands to other uses, meaning agreements with other entities like we read before. So pretty interesting stuff here. Dedications. Legislative power. Let's proceed here. Now we're on to legislative power. Power to lay out or open public parks is generally regarded as legislative, to be exercised by the legislature itself or by municipal boards or other governmental agencies to which it is delegated. Note 1, and that's State versus Board of Park Commissioners of City of Minneapolis, 1907. Collin versus Vernon in Missouri, 1974. And Berg versus Seattle, 1982. So legislative powers. Let's see what we're looking at. Legislative powers here. It's legislative, yeah. So the power is generally regarded as legislative and to be exercised by the legislature itself or which it delegates. So it's going to be delegated to a municipal board or other governmental agency. Similarly, the power to require developers to make a payment in lieu of a dedication for lands of public parks is also a legislative prerogative. And without legislative authorization, look at this, a municipal ordinance requiring such a dedication will be invalidated. Footnote 2. And that's City of Montgomery versus Crosslands Land Company, 1978, Alabama. The state legislature also has the power to place reasonable time, place, and manner restrictions in public settings, such as in parks. In many states, constitutional provisions in varying terms expressly prohibit the legislature from imposing taxes for corporate or local purposes, and normally, the establishment and maintenance of public parks is a corporate purpose, for which municipalities may be authorized to levy taxes under such constitutional provisions. And for which the legislature cannot compel a municipality to impose taxes. Well, it won't take much for them to do that. While the public parks of a city are matters of purely local concern, in which the people of the state do not share a common interest. In the case of parks having an educational value of more than local or citywide interest, the authority of the legislature has been recognized. So parks having an educational value, more than local or citywide interest, then the legislature has authority, not the municipalities. Legislative approval is required when there is a substantial intrusion on parkland for non-park purposes, regardless here. So legislative approval is required when there is substantial intrusion on parkland for non-park purposes, regardless whether there has been an outright conveyance of title and regardless of whether the parkland is ultimately to be restored. So whenever there's a substantial intrusion on parkland for non-park purposes, it requires a legislative approval, regardless of whether there has been an outright conveyance of title. So whether they have actually moved the title or not, it's private until then, right? And regardless of whether the parkland is ultimately to be restored. So any kind of intrusion needs legislative approval. Dedicated park areas are impressed with a public trust for the benefit of the people of the state, and their use, other than park purposes, is either for a period of years or permanently, requires the direct and specific approval of the state legislature, plainly conferred. We get that right. Okay, if everyone's still in here, make sure you hit the like and leave a little something in the chat so I know we're still broadcasting to the interwebs. All right, let's go on to municipal power now. So municipal power, section 6. And of course, the forms here in the American Jurisprudence legal forms, we have a resolution of city officials establishing park and playground. So there's some good forms in there if you happen to be one of your people in your state there making laws and legislation. Okay. Percentage here. Okay, there we go. The authority to establish, maintain, or govern the usage of public parks is generally vested in municipal corporations by constitutional or statutory provision by the state legislature. Okay, it's generally. However, any legislative authorization enabling municipalities to do such things as constructing a park must mean a park that is open to all citizens. In other words, the authorization must be of constitutional import. Some states' constitutional provisions permit an increased municipal indebtedness in respect to the purchase, construction, and repair of public utilities, and public parks have been held included within the term public utilities. Interesting. Volume full. Check, check. Warning, volume low. Volume's low here. Let me check. Let's see here. Testing. Looks like everything's going good here on the audio level. I'll try to get a little bit louder here. Let's double check a few things here. Make sure all is well. Sound. Damn it. You're right, it was down. Check. Testing. Now it should be a lot better. How'd that happen? Shit. Let me leave this open here so I can keep an eye on it. Actually, oh shit, there it is right there. No, that's the wrong one. Internal. Yeah, okay, I'll leave this open here so I can keep track of the volume. Check, testing A, testing B, testing 1, 2, 3. Okay, it should be better now for sure. I think I got it turned up loud. Okay, here we go. Thanks for that. I'm going to keep an eye on this volume here. Yeah. Okay, we're good. While authority to purchase and hold land for a park beyond the corporate limits of the municipality has been denied in the absence of power specifically conferred by the legislature, statutes and charter provisions in a number of states authorize the acquisition and maintenance of parks outside city limits. A city authorized by its charter to acquire and maintain parks, playgrounds, and places of recreation, and to acquire within or without the city such land as may be necessary for the establishment, maintenance, and operation of any public utility, or to provide for and effectuate any other public purpose, may buy land for park and recreation areas outside the boundaries of the city. Wow. As long as it's authorized by its charter to acquire and maintain parks within or without the city. Wow, in the charter. So look at your city charter and see if it has that specific language within or without. Without what? Oh, without the city. Okay. Generally, in the establishment and maintenance of parks, squares, and playgrounds, a municipal corporation acts in a proprietary or corporate capacity. Interesting here. A municipal corporation acts in the proprietary or corporate capacity. However, in some states, this classification has been superseded or modified by the state's Tort Claims Act, while others hold on to the contrary and find that the government's actions in that event are governmental and not proprietary. Woohoo. So again, check your state. Some states in the classification. Now, this is the beauty of American jurisprudence. When we see words like generally, that means, we have to be careful to read our state's classifications, municipal corporation acts, and the proprietary or corporate capacity. Is that, how is that working in your state? Generally, it may be, but it may not be, because this classification has been superseded or modified by the state's Tort Claims Act. So you'd have to look at this and see if it supersedes that classification. It's because other states hold on to the contrary. Find that the government's actions in that event are governmental and not proprietary. So very complex stuff here that would apply to specific cases. And that's why American jurisprudence is so important for us to learn, is that you get all from a multifaceted view of a legal strategy to any type of case, whether you're on the defense or on the complaint side. All right, let's proceed. Finally, the broad power to acquire and maintain public parks has been construed in some states as implying power on the part of the municipality to operate a nursery to supply the park, although such power is not absolutely indispensable to the exercise of the power expressly granted. So the broad power to acquire and maintain public parks has been construed in some states as implying the power part of the municipality to operate a nursery to supply the park. So good case laws here, and that one in particular was number 10. People XREL versus Schweitzer versus City of Chicago, 1936. Section 7, acquisition of land. Okay, and just make sure everything's going good here. Sound still good? Check. Yep. Okay. All customary ways of acquiring property for the purpose of establishing parks are open to municipalities, and the establishment of a public park is a public purpose for which public money may be expended. Since parks contribute to the mental as well as to the physical improvement of the people, and their aesthetic value in large commercial and industrial centers is great, it is proper to expend public money in the acquisition, care, and adornment of public parks. It is proper to expend public money in the acquisition, care, and adornment of public parks. Also, under the rule that a municipal corporation may acquire and hold property for all proper municipal purposes, a number of decisions support the right of a municipal corporation to accept and administer a trust for the establishment or support of a public park or other common. Accordingly, a trust for the construction of a gate or arch at the entrance of a park has been held to be one that a municipal corporation may accept and administer, even though the creator of the trust require that the gate or arch should have an inscription bearing his name and that of his wife. Interesting. That's Footnote 4, 1917, Hagen versus International Trust Company. Oh, gosh. Okay. You just got to have his name on this arch, huh? I think more people will remember him from American Jurisprudence than his name on the arch is probably gone by now. Okay, so let's continue. We're on to generally. Okay. A deed containing recitals or statements that the land is being conveyed for park, right? So this is a deed. Recitals or statements that the land is being conveyed. So we're transferring a deed for a park, or we're reciting, containing recitals or statements that is being conveyed for park or for playground purposes, when properly construed, conveys an estate in fee simple absolute, where a conveyance of land owned in fee simple is made to and accepted by a municipality in perpetuity for use as a park. There's no provision for forfeiture or reversion. The entire estate of the grantor is divested, and the title of the municipality thereto is not a determinable fee, but a fee simple. However, in a number of cases involving deeds conveying land for park purposes, the more or less indiscriminate use of terms in designing estates has been found to create less than a fee simple absolute. All right, guys, fee simple deed. We need to find out what that means. And we're going to do it with Black's Law. And I think it'd be under deeds, if I'm not mistaken. Give me a moment here. Deed. Let's see here. And it's going to be under one of those deeds. Deed. Deeds used a lot in here. It takes me a long time to find it. It's not going to just find it by the word. Here we go. Getting close. Almost. Yeah, if you found it. Okay, so close enough. Okay. So we get on the screen here. Good. So it's a fee simple deed, right? Deed and fee. Title land in fee simple. Usually, okay. So the deed in fee is 18th century is a deed conveying the title to land in fee simple. So we still need to find that fee simple. Okay, so I need to search it otherwise. Give me a moment here. Wow. Okay, let's see here. Fee simple. It's going to be a while if I find this one here. Give me a second. Just about there. State and fee simple. See fee simple. Okay, good. So it is here under fee simple. Are we all still here in the chat? Let's see. I think I got no one left. All right. Fee simple. Where'd it go? Getting there. Gotta keep looking here. Fee farm. All right, cool. Let's look at someone here. Fee simple absolute. Well, let's look at all this fee simple. Oh boy. Okay, we asked. Now we shall receive. Fee simple. 15th century. An interest in land that, being the broadest property interest allowed by law, endures until the current holder dies without heirs, especially a fee simple absolute, often shorted to fee, also termed estate in fee simple, tenancy in fee, fee simple title, exclusive ownership, feudum simplex, and C and his heirs. Okay, so fee simple is a term not likely to be found in modern conversation between laymen, obviously, who would, in all probability, find it quite unintelligible. Yet to a layman of the 14th century, the term would have been perfectly intelligible, for it refers to the elementary social relationship of feudalism, with which he was fully familiar. The words fee and feudal are closely related. The estate in fee simple is the largest estate known to the law. Ownership of such an estate being the nearest approach to ownership of the land itself, which is consonant with the feudal principle of tenure. It is the most comprehensive estate in land which the law recognizes. It is the most extensive in quantum and the most absolute in respect to the rights which it confers. Now, quantum means measurable, right? And the most absolute in respect to the rights which it confers of all estates known to the law. I prefer fee simple too. Traditionally, the fee simple has two distinguishing features. Let's see what they are. First, the owner, tenant in fee simple. Notice this tenant is the owner. Has the power to dispose of the fee simple, either inter vivos, between living people, or by will when he's dead. Second, on intestacy, that the fee simple descends. Intestacy, the fee simple descends. The absence of lineal heirs to collateral heirs, to a brother, for example, if there is no issue. Wow. So if fee simple, the power to dispose of the fee either by will or inter vivos. Okay? Fee simple, originally, this was an estate which endured for as long as the original tenant or any of his heirs survived. Heirs comprise any blood relations, although originally ancestors were excluded. Not until the Inheritance Act, 1833, could a person be the heir of one of his descendants. Thus, at first, a fee simple would terminate if the original tenant died without leaving any descendants or collateral blood relations, e.g., brothers or cousins. Even if born before his death, the land had been conveyed to another tenant who is still alive. Wow, but by 1306, it was settled that where a tenant in fee simple alienated the land, the fee simple would continue as long as there were heirs of the new tenant, and so on, irrespective of any failure of the original tenant's heirs. So the fee simple continue if there's so alienated the land, but as long as there were heirs of the new tenant, and so on, irrespective of the failure of the original tenant's heirs. Henceforth, a fee simple was virtually eternal. Wow. And a fee simple absolute is an estate of indefinite or potentially infinite duration, often shortened to fee simple or fee. Also termed fee simple absolute in possession. Although it is probably good practice to use the word absolute whenever one is referring to an estate in fee simple that is free of special limitation, condition, subsequent, or executory limitation Lawyers frequently refer to such an estate as a fee simple or even as a fee. Okay, so there we go. Deep dive into the fee simple, which is not that simple as we break it down, except to the people that are using it. Let's continue here. Thus, a deed granting land to a city for park purposes may be held to create an estate upon a condition subsequent. Similarly, a conveyance of property to a city to be used as a public park, containing the provision that the title would revert to the grantors or their successors if the property ceases to be used as a park, creates a fee simple subject to a condition subsequent. Likewise, an estate in fee subject to condition subsequent is created by a deed containing the provision. This conveyance is given upon the express condition that the two parcels of land above described shall be used solely for park, highway, street, or boulevard purposes, and if any part thereof be not used for any such purposes, or at any time ceased to be used for such purposes, or at any time be used for any other purpose, said part or part shall immediately revert to the grantor, its successors, or assigns, and it shall be lawful for the grantor, its successors, or assigns to re-enter and repossess the same, or any part or portion thereof, and thereafter to peaceably hold and enjoy the same as if these presents had not been made. I love that language there. Also, the language used in a deed. That is footnote 6. We got to check this one out. Who wrote that beautiful phrase we can use? Central Land Company versus City of Grand Rapids, Michigan, 1942. Good old days. Okay, so also the language used in a deed that premises conveyed are to be forever used by the town as part of a public park, and the playground expresses the intent to create a trust in perpetuity of the subject parcel, where the language in the other deed granting land to the town for public park purposes, but providing that the town fails to keep and perform the condition that the property be used as a public park, the deed shall become null and void, creates the possibility of a reverter that is inconsistent with the intent to create a public trust in perpetuity. Where the language employed is capable of being construed either as a covenant or as a condition, the courts are inclined to construe it as a covenant. Particularly, where there is no express provision for a reverter or forfeiture, provisions in deeds purporting to limit the use of land conveyed to the park or playground purposes have been held or considered to create a trust. So, remember the trust that we went over last time is as the language and the intent. So, if there is no express provision for reverter, the provisions in deeds purporting to limit the use of land conveyed in the park or playground have been held or considered to create a trust. Thus, under a deed providing that property conveyed is to be kept and used as a public park in perpetuity, the grantee town will take and hold the title to the property as a trustee under a public charitable trust, requiring it to use the property, and the legislature lacks the power to impair this obligation. So we can't have any kind of laws that are going to override this trust, charitable trust. Okay. Likewise, where the deed of a lot to the municipality stated that the conveyance is made upon the condition that the lot would be forever held and maintained by the city as public park to be named Winslow Park, and that there shall be placed and forever maintained within said park a tablet bearing an inscription honoring the grantor's parents. Failing such conditions, the lot would revert to the grantor, and the deed would be interpreted as creating a charitable trust with the purpose of providing a park and honoring the grantor's parents, since, as so interpreted, the city would have an affirmative duty to abide by the provisions and can be ordered to comply. However, when the trust fails because of the state's taking of the lot by eminent domain for freeway construction, the Cypress Doctrine would be applied to allow the establishment of another park bearing the same name in a different location with a monument plaque to be moved there too. Wow. So they could move it if they get taken by eminent domain. Wow. The site press doctrine. Wow. That's interesting there. Some cases hold or recognize that a statement in deed that the land conveyed is to be used for park purposes prevents an absolute title and fee from passing, without deciding that a condition subsequent is created, and without discussing the exact nature of the estate conveyed, merely limiting the use of land in accordance with a deed provision. Where land is dedicated by the owner by a common law dedication, a different rule applies, and the effect of a dedication of land as a park or square is generally considered to create an easement in favor of the public, coextensive with the purposes to which public parks or squares in such localities are usually applied. Footnote 14 on that. 1908, 1910. Interesting stuff here. Hey, you made it. Okay, let's get back to where we were here. Whatever the mode of acquiring title, there appears to be no doubt that when title in fee is acquired, there is no right of reversion to the original owner, he or she being divested of every vestige of title when he or she parts with the fee. So remember, that's the fee symbol. The public body takes the title to land in fee for public use as a park and holds it in trust for that use. However, it is not the owner in any ordinary sense, and its rights hardly extend beyond a technical title without the usual incidence of title. Yes, you have rights, cops have duties. Write this word down for me. You see that word in the chat? You have rights, cops have duty. Write that down. Did you write that word down? It's a very important word to write down. Got it? Good. Remember that. Tomorrow we're going to do the one about the public utilities. And we actually mentioned a little bit of that in this one here. And this is kind of a segue into that. I understand that this topic here can be very dry to some that we went over here. But the reason I went over this is because, again, some of these things with American jurisprudence, by us going over this, whether you realize it or not, we're actually learning a progression of knowledge that allows us to interpret more and more of this law at a deeper level, so that eventually, you know, my goal of all this is to give us an ability to practice law at a level that's beyond even the Esquires and even the Fudges and everyone else. That if we could have a deeper understanding of our rights under our courts and our laws that are meant for the people, that we can once again take control of what was meant to keep the peace here through justice and jurisprudence and not through violence. Because this is the only way we can actually achieve a lasting peace, is through our style of American jurisprudence, I believe. We've seen failures across the world and throughout time with other approaches. And so far, as we can see, this country's style of jurisprudence has proven to be one that's been attracting the most people from around the world to come to. Which word? Clerk of the court? I get other names for clerk of the court. I don't know if I'm allowed to say them here. But that being said, we can take off on this one next time on leases, because I know we're getting a little bit deep into this stuff here now, and I don't want to get us lost in the weeds. No, you get it wrong. But in general, what we're looking at here is to get a a good view of what we mean by public parks, squares, and playgrounds. The National Park Service role in all this, state laws and legislator are the ones that actually assign duties for or authority to municipalities and cities, etc. They're delegated powers that come from a legislature of the state. And then we also have national parks. So there's a whole federal layer to the national parks. And then we have eminent domain, which can take control of land that was originally for a park. And then we have trusts that could be donated to parks or land acquired in other deeds acquired for parks. That would also fall into certain legal pitfalls should conditions change regarding that conveyance or transfer of the deed of the property. So that being said, I hope that everyone was able to get something from this. Again, I want to have a foundation of understanding some of the basics of what we're getting into as we explore American jurisprudence, because it's a very deep topic. Again, it's something that requires a education and knowledge too. I don't see them offering this these days in even in law schools, for that matter. And it's not just our duty, but really for posterity, it's kind of what we are obliged to do for what other people have sacrificed for us to have. And on that note, I would like to thank everyone for joining. And you have rights, cops have duty. I don't know how to reach out and get in touch with you, but tomorrow we'll be doing a live stream, I guess around the same time, 11:30 p.m., perhaps earlier if you prefer. What's the best time for you? Hiking in natural areas considered. Okay, so again, we had an area that we were at. Let me get back to that section here where we actually did have a. Come on, now let me get back to it here. We were looking at an area where they had some stuff on hunting. Wow, try to tell you're a vegetarian. I just want to read one more thing here because this was a important aspect to read. Because again, it's for our enjoyment of these parks, and the purposes come into the law. They can't have laws that go against fundamental purposes and constitutional rights. But if you don't invoke them, then of course they're not going to honor them. Give me just a moment here. I'm going to find it because we just read it. So again, it's haven't made all my notes from this yet while I was reading it. What are you researching it? No, don't. No, it's one word. Just write it down. I'll tell you why later. You have rights, cops have duties. It's one word, and don't look it up. Just write it down. All lowercase. Just write it down. All right. So, yeah. So let's see. Wildlife. So is to conserve the scenery and natural history and the wildlife therein to provide enjoyment in the same manner. Let's see here. Hang on. It was a national park you said you were in, or a natural area, city park? Okay, so it's a city park. So just give me a second here. There was something in here where it was mentioning about the uses of them. So it was a national park. Good. So let's get back here. Help if I went top down, probably. And yeah, so the words squares. So rural park in the middle of the city has less than 1,000. Great. Because this is something also where we talked about that it can't, regardless of the city, if it's got some type of educational purpose that is of interest beyond that city population, then the city can't, it reverts back to the legislator as far as laws go. So the legislature would supersede anything that the municipality has regarding education for people outside of their district. Recreation, health, youth fair. Yeah, here, see, I think it's underbrush. Oh boy. Yeah, we had it here somewhere. It was, I thought I had it here in the beginning, but I guess not. Yeah, we have, let's see here, permissible uses, abandonment, discontinuous. Give me 1 second here. I'm going to look up one more time through a search. It's going to give me one moment here to pull it up. Yeah, let's see here. I can't quite search on the live stream as easily. And hunting, it was a hunt we were looking for. What? Here we go. Oh, shoot. Right to hunt on public lands, fish, game, wildlife. Yeah, sorry, that was it's in another edition. It wasn't on this one. Okay. Good enough. At least we checked that out, so we see there. Yeah, it was over here on Treat Elsewhere in right to hunt, fish, and public. So I got to look on the fish and game wildlife conservation for that one. Now, it depends on your state laws too. So if you're familiar with your state laws regarding the parks, then that would supersede anything they have in the city ordinances, I believe. Yeah, and they left. Yeah, well, usually you challenge people like that. Good job, because I believe they were going beyond their authority, and that's why it's important for us to know this. Is that the primary purpose? All right, so let's just read this again here, because this gets at the heart of what you could say to anyone, because it's in plain English. And how can their laws get around this? See, thus the term park means a piece of ground acquired by a city, town, or other public authority for ornament and as a place for the resort of the public for recreation and amusement, as well as ground set apart for public health and welfare. So if you're guarding yourself, public health and welfare, I guess, is still in the purpose of a park. Park is a pleasure ground set apart for recreation of the public to promote its health and enjoyment. Okay, so in modern times, the principal purpose of a park, namely public recreation, is not limited to physical recreation, but includes aesthetic recreation and mental and cultural entertainment as well. So those are some important things to consider. And then lastly, the observation. The definition of a park may in some jurisdictions be provided by statute or other legislative act. So look at your state statutes. A wildlife refuge, while not within the conventional definition of a park, may be within the meaning of that term as intended by its use in a constitutional provision. So look at your state constitution. Yeah, well, that's key, and I'm glad that you had that experience, because that's the experience we all need to have. Is that we need to be the ones in charge of our own country and our own laws. If they're not going to honor their oath, if they're not going to do things in the proper manner, then this is what we have to do: is educate them. Yeah. Excellent. So I'm glad this resonated with you. Sometimes it's that's just the way things work. Again, mostly what we're doing here is just to gain this general knowledge of American jurisprudence. As we go through this journey, I believe we're going to have such a strong foundation that every aspect of the law, it'll permeate and give us an advantage and a benefit that it'll help us regain control of what's left of our justice system, so to speak. But again, this is for the people. All these things are supposed to be for the people. And for us to play victim and not take advantage of the power we have through our system of jurisprudence would be for us to just, give up. And I don't believe that's in the spirit of us here in America. So again, I want to thank everyone for coming along on this journey. And please subscribe and hit that bell notification so that you can be alerted for the next one. On that note, I would like to thank everyone for coming, and I hope to see you all on the next one. Peace out.